about Mr. Liu's point that miscarriage wasn't used as a verb at the time the statute was enacted. You know, Justice Kagan said, well, you know, you can lose the mail, you can negligently transmit the mail if you're the postal worker, or you can miscarry the mail, as in, you know, misdirect it to the wrong place. And one of the responses that Mr. Liu had to that point was, well, miscarry wouldn't have been used as a verb. It was this term of art. What's your response to that? Because I do think it matters whether you view these words as something that happens to the recipient or something that was done by the postal worker.
Right. So I'll answer the miscarry question, and then I want to say one more word about that. So he's right that in general it was seen as intransitive, but the Webster's first and Webster's second dictionaries we point to note that it was sometimes used transitively. So you could say, I mean, in fact, Dolan says mail is miscarried if it goes to the wrong place. I'm not sure it matters a ton. You can kind of rephrase the question to get at the agent in a different, you could say, did the letter miscarry by Rojas? Was the mail lost by Rojas? And I think you're still in the same place. And I think whatever you think about miscarriage, it has to be clear that all the other nouns throughout the exceptions are not just did this happen, it's did the government employee do this, right? We give the example of assault. You don't come into court and say like, there was an assault. You have to say the government employee assaulted someone. And so we think the same thing is true of loss. Again, if you don't buy that argument, I think the two other ways to think about the loss term, the first is sort of what we say in our brief, which is that typically loss is thought of as unintentional, and whether it's insurance contracts or cases or 1346B itself, people usually specified intentional loss or loss caused by wrongful conduct when they meant to change that default. And second, again, if you buy our miscarriage mens rea argument, there's just no good reason why Congress is saying one term encompasses wrongful conduct and the other two don't, particularly where, as Mr. Liu noted, there's some redundancy and certainly some overlap among the terms. If I can make one other point about consistent usage, and then I'll turn it over to Sariad in questioning. In 1346B, Congress is using loss in just a fundamentally different sense than it is in 2680B. We knew that because of the three textual clues that I gave you, and as a result, I don't think that the presumption of consistent usage even attaches, because it's only about where two terms are both being used to mean, for instance, deprive and deprive, the same source of deprivations count. It doesn't say that any time a term is used, it must be used in the same sense.
Thank you, counsel. Justice Thomas? Justice Alito?